Well, welcome. Thank you. It's great to have nice big crowd. I'm Liz Isaacs, and Lauren Peretti is here from Housing Innovations, and we're really excited to have Connecticut Fair Housing Center with us this afternoon. We have Nazneen Hussain and oops, I just lost you. Melissa Marichal. They're going to give us great information about how to keep folks safely, stably housed, learn a little bit more about all the different eviction moratoria going on out there. And we're excited to have them. And I'm going to turn it over to them so that they can start sharing their screen and sharing their presentation.
Great. Thank you, Liz.
Sure.
I'm just going to bring up slides here and then introduce myself in just a second.
That's great. And while you're doing that, I'll let folks know that please feel free to use the chat box at any time. We'll also have time for questions so we can see if it works best in chat or if we're able to do some unmuting, but we actually have a pretty large crowd. When we're over 100, the chat box may be the way to go. But feel free to ask away.
Okay, great. Thank you. Maybe Melissa and I could start off by introducing ourselves. I am a community education specialist and a tenant organizer with the Connecticut Fair Housing Center. And Melissa, my colleague, and I will be co-presenting. Melissa, do you want to introduce yourself?
Sure, yeah. I'm Melissa, and I'm a staff attorney at the Fair Housing Center, and I focus primarily on eviction.
Great, thank you. So as we said, we are from the Connecticut Fair Housing Center. Our physical office is in Hartford, but we operate throughout the state. And actually currently most of the staff is working from home. But we are offering a full range of services that I'll talk about in just a second here. So for anyone who is not familiar with the Fair Housing Center, the mission of the center is to ensure that all people have equal access to housing opportunities in Connecticut, based on both federal and state fair housing laws. There's a number of different areas of work that we focus on. We offer free legal services to people who might otherwise not be able to access legal services in addressing housing discrimination. We also do fair housing testing, investigation, and education. We do foreclosure prevention work and also either legal assistance or testing and investigation around fair lending practices. And then something relatively new to the center is primarily driven by the eviction crisis we see that's been made worse by the pandemic. We now also have a focus on eviction prevention and education around eviction prevention. So today we are going to cover mostly some updates around the issue of rent payments or people who cannot pay rent, and how the different eviction moratoriums that are currently in place can impact or assist people who may be at risk of eviction at this time during the pandemic. So we'll cover some basics. Melissa will cover some basics about the eviction process. I'll provide an overview of the state and federal eviction moratoriums. And then Melissa will also give us an update on how these moratoriums are impacting the courts and how the courts are processing eviction cases as well. And then if anyone has questions about broader fair housing protections, as well as any clarifications or questions about the eviction moratoriums, we're happy to expand on anything that we present. And I can also provide some background on specific fair housing protections that people have questions about. Melissa, do you want to start with this process? And just let me know when you're done, and then I can cover the moratoriums.
Sure. So in explaining how the moratoriums impact things, we thought it would just make sense to have a brief overview of how eviction in the state of Connecticut works, because we often get, and I'm sure you guys also get questions and calls from tenants who might say that their landlord told them that they have to leave by the end of the week, or that there's going to be a marshal at their door on Saturday, and or they're not going to extend their lease, and what does that all mean? And so I think an important thing to understand, kind of the most fundamental thing about the puzzle to make sense of the moratoriums, is that in the state of Connecticut, in all states, there's several steps a landlord has to take in order to get permission to evict a tenant. So they can decide not to extend a lease, but that's actually not the first step in starting the formal eviction process, which is a legal process that through the end, they need to eventually get the permission of the court to evict that tenant. And so the first thing that they have to do in order to really start that process is serving what is called a notice to quit. And a notice to quit is a legal document. There's legal requirements of what it needs to include. It can't be served by the landlord himself or herself. It has to be served by a third party, usually a marshal. And so that's the first thing that tenants usually get. And that's what they have to get in order for the process to start. That's going to give them a date in which they have to leave by. Oftentimes, tenants think that means that that's the end of the process, that they must leave by that date that they see on the notice to quit. But actually, it's just the beginning of the process. And if they can't or don't want to leave, they do have the right to stay. And then the landlord must start a court case. So if they choose to stay past what's called the quit date, which is the date on the notice to quit, then they can a court case. The landlord can choose to start a court case, and the tenant can fight that court case. So if they stay past that quit date, the next step is that a landlord would start the eviction court case, and tenants would receive what's called a summons and complaint. So it looks like court papers, and it's going to give the tenant information about how they have to respond to those papers. And in Connecticut, you probably have heard about this. The term for eviction is called summary process. It's called summary process because it's supposed to be an expedited process that's a little bit different than most other civil cases, but that's what it's called, summary process. But we also often just refer to it as eviction case, summary process case, the same thing. And so in that court case, there's going to probably be hearings, but they have the right to a trial. And through that court case, by the end of it, if the landlord is successful, what they're seeking is a judgment, an order from the court, first gaining judgment, gaining possession through the court process. If they win in that process, then they have to go to the court and actually ask them to issue a court order called an execution. The execution that's actually the order that actually gives a state marshal permission to actually remove a tenant from their home. So oftentimes when people think about eviction, they might picture people's things on the streets or being, removed from your apartment. That doesn't happen until to the very end, after a court case has been won, after the court has given this execution order to the landlord, and the landlord then has to give it to a marshal, who is the only person that can then, they give that notice to the tenant and give them notice, usually with at least 24 hours notice of when they're gonna come, and if the tenant is still there, then at that point, they can remove them and remove their belongings, and then they would stay with, possessions would go to the town. So that's just a little brief, really, really, really brief summary of that process, but I think it's helpful in just understanding, we hear the word eviction a lot, but there's this whole kind of life cycle of how that works. And in the meantime, if a tenant hasn't paid, or if the tenant has received things like a notice to quit, the landlord doesn't yet have possession of the unit. It's still, if the tenant is still living there, if they're fighting the case, they still have what's called possession or the right to be there. And so in the meantime, a landlord cannot lock out the tenant. They don't have that right to take over the unit in any way, whether it be literally locking the tenant out or in kind of constructive ways like cutting off the utilities or things like that. And in those cases, a tenant has a right to contact the police if they've been locked out, or file a civil case to gain entry back into their apartment. So those are things to keep in mind.
Thank you, Melissa. And as someone who does outreach to tenants who are facing eviction, I think some of the details that Melissa provides here are really important, because we do, at least at the center, hear a lot from tenants who are very unclear as to what is expected of them when they're given a notice to quit, for instance, or if a landlord informally tells them they have to move out by a certain date. And of course, a tenant can, if they, especially right now during the pandemic, if they have access to other housing and they can safely move out, they can do so. But it is also important that tenants know that they have the rights that Melissa just outlined as well, just in my experience of talking to many tenants who are at various points in the eviction process. So given this process, I am just going to go to speaking about, there are actually currently 2 eviction moratoriums in place in Connecticut, one state moratorium and a federal moratorium, or one that is nationally applicable. So I will cover the basics of both of these, starting with the Connecticut eviction moratorium, and then talking about the national, or the one that was issued by the CDC. So for the Connecticut eviction moratorium, this is something that the governor put in place through an executive order back on April 10th. And it has subsequently been extended several times. Most recently, it was extended so that to say that landlords cannot file most new eviction cases until January 1st, 2021. So the moratorium is extended through December 31st of this year. And this is important to note that this is a moratorium on any new eviction cases. And then in a little while, we'll explain why that's important to note as well. So this also does not cover all new eviction cases. There are some very important exceptions to this moratorium. The 4 categories of exceptions are landlords may still file a new eviction case before January 1st if the tenant owes 6 or more months of rent that was due on or after March 1st, 2020. Being important because of when the original moratorium went into effect in Connecticut. The second exception is if the tenant owes rent that was due on or before February 29th, 2020. So that was, again, this is has to do with the date when the moratorium went into effect regarding with regard to the pandemic. The other exception has been in place since March. There is an exception for serious nuisance cases. And serious nuisance is, for example, if a tenant is a threat or is causing harm or has caused harm to another tenant or the landlord, for instance, being physically harmful or abusive or something like that. And finally, there are exceptions also in the case of these new eviction filings, where if a lease has expired and the landlord wants to then subsequently use the unit as their primary residence, then landlords may still file a new eviction case. So if there are any questions about these exceptions, I'm happy to answer them once we take a look at the questions in the chat as well. Tenants, it is important to note here that neither of the moratoriums mean that tenants can stop paying rent. They are still required to pay rent. Even if they are not able to pay their rent in full, it is still required that they pay as much of their rent as possible and on time as possible. And especially with the CDC moratorium, as we'll see in a couple of seconds, there's a requirement that people also seek out rental assistance if it is available. But this is an overall summary of the Connecticut eviction moratorium. And so I want to provide us with a summary of the federal or the CDC eviction moratorium. So back in early September, the Center for Disease Control and Prevention issued a national ban on evictions from September 4th to December 31st, 2020. Unlike the state moratorium, this is not automatic, meaning that tenants actually have to take some action in order to be protected by this moratorium. So in order to do this, if a tenant would like to be, or if a tenant feels that they can be protected by the federal CDC eviction moratorium, there is a declaration that they must complete and give to their landlord. But I'm going to go through some very important steps that they have to make sure they cover in doing so. So every adult in the household, in the respective household, anyone who is 18 or older has to do the following. Each of them has to carefully read the CDC declaration, and there is a link to the declaration that I believe Liz will also share with you after this presentation. But they have to read the tenant has to read, or every adult in the household has to read the declaration carefully and make sure that they are eligible to fill out the declaration and give it to their landlord. I will go over the requirements in the next slide for that. So tenants, it is important to note this because tenants could potentially face criminal charges or fines if they provide inaccurate information or if they submit the declaration to their landlord knowing that they do not qualify or they're not eligible to actually submit the declaration. So once a tenant goes over the declaration and makes sure that they are eligible and that they meet all of the requirements, they can sign this declaration and then give or send the declaration to their landlord. We recommend that the tenants send this to their landlord in some way where they can have some proof that they sent it, and they have some verification of the date when they sent it as well. So an email, if someone can scan or take a picture of the declaration and send it via email to their landlord, that would be good. Or if they could send it through some sort of mail where they get some sort of tracking number to say, right, that it was delivered to the landlord. So that's our recommendation, but the CDC simply says that the tenant has to sign and give the declaration to their landlord. Also, it is very important that the tenant keep a copy of the signed declaration that they provide to the landlord, along with any proof that they meet the requirements and any communications that they have with the landlord regarding either rent they owe, or any kind of payment plan or any communication basically with their landlord. The tenant is not required to submit proof that they meet the requirements directly to the landlord. They only need to give the declaration. But in case the landlord challenges any of the eligibility criteria, or say that the tenant is not in fact not eligible for protection through this CDC moratorium, it is important that tenants have on hand any documentation that shows that they meet the requirements. And tenants who already have an open eviction case may still qualify and be able to use this declaration. So this is unlike the state eviction moratorium, which only applies to new eviction cases. The federal eviction moratorium can apply to existing cases as long as the tenant qualifies with regard to the other requirements of this federal eviction moratorium. And the requirements are basically these, right? So the first is the tenant has to attest that they cannot pay their full rent or other housing payments because their household either lost income or has very expensive out-of-pocket medical bills. The declaration has a particular percentage listed on it in the fine print, so tenants can take a look and see if their out-of-pocket medical bills meets that requirement. And this is very important. Tenants have to be able to show that they lost income or have these extraordinary out-of-pocket medical expenses. The tenant also has to attest that they will likely become homeless or forced to live in someone else's home under crowded conditions if they are evicted. And this is because the CDC issued this moratorium primarily to prevent making the public health crisis worse. And so the tenant has to attest that essentially they do not have the option to safely move out into another home. The tenant's household income for 2020, they have to attest will be less than $99,000 for an individual, or if it's a two-person household, that it'd be less than $198,000. Tenants could also alternatively have qualified for a stimulus check, or be able to show that they did not have to pay income tax in 2019. So you don't have to meet all three of these conditions as a tenant, but you do have to meet at least one of those, the income requirements. Tenants also promise in the declaration to pay as much of their rent as possible on time, even if they cannot pay their full rent at this time. And they also have to show that they made their best efforts to apply for any government rental or housing assistance. And currently the state rental housing or the rental assistance program is closed. They may open back up. If they do, we can certainly share that information. But in general, tenants can call 211 to learn if there is any rental or housing assistance available, and how to apply if it is available. So if tenants do apply or call 211 and attempt to find out if there is any assistance they can apply for, they should make a note of this and keep this information as proof that they did make efforts to apply for rental or housing assistance. So I think we will move on to the status of the courts, with Melissa giving us an update about those. And maybe Melissa, if I missed something about the moratoriums, maybe you could add that too.
Yeah, sure. So I think, you know, thinking about the Connecticut moratorium and the CDC moratorium, Connecticut moratorium stops some filings. The CDC moratorium could stop some filings that are not covered by the state moratorium, and it can also stop cases that are already in the court system. So, so in order to make sense of that, just a review of where the courts are right now, they are processing cases, both cases that were filed before the pandemic, before the moratoriums. So those cases might be from January or February, and they're also processing cases that were filed in the last few months because they didn't qualify for a protection. So those are being processed. And how are they being processed? They're currently starting to schedule remote mediations or remote hearings. And they are also, there's different deadlines and requirements that, you know, that the defendants, the tenants and the landlords, the plaintiff have to meet in this court process. During the beginning of the pandemic, the courts had put a suspension on the deadlines to file the appearance and answer that a tenant has to file in response to receiving a complaint. They have, in September, they removed that suspension. They also removed the stay on execution. So that's, I had mentioned earlier that executions are the orders that give the marshal the permission to remove the tenant. So for many months during the pandemic, they had put a stay on that. So no one was actually being physically removed from their unit, but that stay has been lifted. So that means that tenants are responsible for, if they do receive eviction papers, they're responsible for timely responding and filing appearances and answers. So if they receive a summons and complaint, if they receive eviction papers giving them a date by which they have to file an appearance and answer, that deadline applies, and they are sticking to that deadline. So the court could issue what's called a default judgment if if you don't appear or file those papers on time. And the court could choose, and is starting to issue these execution orders, which are allowing marshals to remove tenants from the units. So it's really, really important that tenants understand that the courts are ostensibly open and the clerk's offices are ostensibly open, but there are limits in terms of what this actually looks like in practice. So right now there are no in-person appearances or hearings. Everything is being scheduled remotely on Microsoft Teams. So if tenants do have a hearing or do have a mediation, they're getting notices from the court about a Teams meeting. And they often, if they haven't already given the court an email address, the notice will tell them about how they need to give the court their email address. So these things are things that we're trying to get the word out about because it's really new. This just started in September. And so that's why the CDC moratorium's applicability to cases that are already in the court system comes up now that the courts are starting to move cases along. And so in situations where a tenant doesn't already had a case filed and they're at the end of the case, they've already lost the case and the landlord has filed for this execution order. Right now, that's kind of like the final stage of the eviction process. But because the CDC declaration, the CDC moratorium covers tenants in that situation where they have lost the case, but they haven't been removed yet from the unit. And so the courts are holding hearings in many of those cases where they're about to sign this execution order, giving the landlord permission to hire the marshal to remove them. And so tenants in those situations are probably going to be getting, if they haven't already, notices about remote hearings in which if they've signed a declaration, the court will ask them about that declaration, and they might try to ascertain if that tenant really qualifies for the CDC moratorium. So that's where we're seeing that declaration in the CDC moratorium come into relevance here in Connecticut. And that's the most immediate part of the process where it's coming up, but also as the courts start to process more cases, it's going to also start coming up in other cases that are cases that were pre-existing or were filed and not covered by the state moratorium, but now have hearings or trials in the state courts. And if the tenant has filed a declaration, then they may be protected by that. And it may be the case that the court must stay that eviction case through December 31st. The executive order actually says that once a landlord has received the CDC declaration, that they must cease any action to evict the tenant. So that's our understanding of the protection is that a landlord cannot take any further steps through December 31st. So for people who have cases actively in the courts, it's important that they know both that the courts are open and that they should be watching out for notices or information about upcoming events in their cases and responding to those, and also to know that they may qualify for the CDC moratorium's protections and that they should closely read the declaration and see if they qualify. And if they do, to give that declaration to their landlords. And so relatedly, in general, if a tenant receives eviction papers or also on information from the court on notices like remote hearings, they are welcome and advised by us to immediately apply for legal assistance. I'm sure many of you know, but in the state of Connecticut are the main entryway into getting free legal assistance is by calling statewide legal services. That 1-800 number is open from Monday through Friday, 9 a.m. to 12 p.m. and 1 to 2. And they take applications for most of the regional providers, and they also themselves give legal advice. So if people are receive eviction papers, that 1-800 number is a really good number to give out to people. Additionally, we have an FAQ that kind of goes over a lot of what we have just explained about the 2 different moratoriums on our website. And so that's another document that is just an easy kind of brief summary of 2 pretty confusing protections that we have right now. And then the third is on ctlawhelp.org. There's a lot of information about the eviction process, both about these updates that are coming down frequently, and also just general information about the eviction process, about how court cases work, and about a whole host of other legal aid related legal service information, from how to seek a civil protection order to how to apply for different types of benefits. So those are all resources that we recommend that you check out, and definitely feel free to share widely.
Thank you, Melissa. I just want to at least conclude this part of our presentation before taking any questions and clarifying any questions you may have. In broadly speaking, whether people are dealing with discrimination issues or evictions in-house, when it comes to landlord-tenant communications, we highly recommend that tenants document any communications with their landlord. So this can include saving any letters, notices, payment receipts, even emails, texts, or voicemails that you receive or send. This type of documentation can often help us figure out what kinds of communications were exchanged, when they were exchanged, and if there is any confusion around what happened. These often help us. So if you reach out to us for help to clarify what happened and what options tenants may have in resolving problems or issues that they may be facing. Also, we want to emphasize that along with the statewide legal services number that Melissa just gave out, please feel free to contact us if you have questions or concerns as well. Tenants do not have to deal with discrimination issues, especially, or in this case, eviction issues, on their own. If they would like some advice or clarification around the different eviction moratoriums right now, give us a call, and you can speak with someone at the center and have your questions answered and seek any other assistance that we might be able to offer you. And also, just to reiterate what Melissa said, please do not ignore any eviction papers or hearing notices that you might get from the court if you are facing eviction as a tenant. You should definitely follow the instructions and respond, or make sure you attend a hearing so that these cases are not decided against you just simply by default because you did not respond. And then finally, before we take questions, this is our contact information for the Connecticut Fair Housing Center. Both phone numbers. One is a toll-free number in case anyone is worried about minutes. And you can contact us via email or go to our website. Our website has a lot of resources as well, and you can contact us through the website as well. And then finally, right now, just again want to note that the eviction moratoriums don't mean that tenants can stop paying rent or will not owe this rent to their landlords, even if they cannot pay it on time right now. And so we are advocating for the state of Connecticut to really make available more resources in terms of rental assistance, and to help both tenants and also a lot of small landlords who might be relying on that rental, on those rent payments to pay mortgages, etc. So if you are facing eviction, if you are having trouble accessing rent relief right now in a time of need, we also highly recommend that you contact the governor, contact your legislators, and let them know about the need that there is.
Shut down because of COVID. At first, it was just one school. Now it's all the schools.
So so I will stop our screen share for now. We can come back to the slides if people have specific questions about any of the content from the slides. But we can take a look at the questions in the chat. Or I don't know, Liz, how do you want to?
That's fine. If you so the question is providing the tenant the local legal services per town just as helpful as the toll-free number, or are the calls managed through the toll-free statewide number?
So, so for basically, almost every call is managed through the toll-free number through statewide legal services. Usually if you contact the local office, they will actually just tell you to call and do an application through statewide legal services through the 1-800 number. However, the one exception is for undocumented residents who do not qualify, unfortunately, for the services of statewide legal services. So in that case, when we work with undocumented residents in the state, we give them just their local legal services numbers. If they contact directly those offices, the offices are prepared to do individual applications for those residents. However, if they do end up calling statewide legal services will do the same. They will just give them the number of their local legal aid office. So either way, they'll get to the right person to do their application, but it's mostly just an efficiency process that statewide legal services does most of the intakes and then refers.
Great, that's helpful.
I did have I had a question. I think it might have just been sent to me asking if there's a way to try to negotiate with the landlord to stay if someone is facing eviction. And certainly if tenants feel comfortable and they feel they can do so, they there's nothing to prevent them from talking to their landlord about making an arrangement to a different rent payment plan or something like that. But I think especially that last or the second to last slide that I showed with the recommendations about documenting any communications would be important there, just to understand exactly what was agreed to, if there was an alternate payment arrangement made, for instance. And landlords are also can potentially share the information about the eviction moratoriums or rental assistance with their tenants, just as long as they don't do it in a discriminatory or sort of in a way that is forcing tenants to do something that they may not qualify for or be eligible for, or something like that. So so there's nothing to say that you cannot talk to your landlord if you're a tenant and you want to try and stay in your current housing. Our recommendation is simply that you document it so that the terms of whatever agreement you reach are clear to both parties.
Great. And I see a question that says, what is the typical time frame for the eviction process from notice to quit to execution, and what is the best guess for that time frame once the moratoria expire?
So it really depends on each case, but generally like 35 days around there. Is like a general average, but it really depends on, how a tenant responds to the papers and when things are scheduled. In terms of how that time frame will look after the moratoria expire, the sense is that the courts are very much behind, and they are technically trying to process cases right now that don't qualify for the moratoria, but it's going slowly. So it's definitely to be expected that it will be slower, but it's hard to say with certainty how much slower. It's also interesting to note that they've now that they are currently relying on these remote hearings through Microsoft Teams, in some ways, it seems like things are also going a little bit faster, actually, because we've learned that the remote hearings have a designated amount of time. So they'll schedule a 2 o'clock hearing in one case and then a 2:30 in another case. And because of these limited time frames, that there's some sort of sense that judges might be, like have a different sense of time and interest in moving through cases that is different from what it looks like in a court room in a normal day. So it's really a lot of different variables going on, but we certainly can predict that it's going to be slower going.
Sorry about that. Whoops.
I think I saw a question.
No, I just lost it. Yep. What qualifies as a serious nuisance for eviction, even with the moratorium?
So and Melissa can add if I don't cover this fully, but the definition of serious nuisance is not changed by anything in the moratoriums. So the same definition that applied beforehand would apply now as well. In general, a serious nuisance would be something such as either threatening or actually physically harming another tenant, the landlord, and that something like that. I don't know if there was any other types of situations that are common in serious nuisance cases, Melissa, but my understanding is that that the definition of serious nuisance has not changed with the moratoriums. It's just that the state moratorium has an exception. Landlords can still file an eviction case if a tenant is threatening or physically harming another tenant, or is threatening the landlord or physically harming the landlord.
Yeah, that's correct. It's the same statutory definition as always. It's just a carve out for the moratorium.
This is Lauren at Housing Innovation. So one of the questions that we've had come up in other COCs as well as in Connecticut that we work with is whether or not, because of the moratoria, whether or not people are still eligible for ESG prevention services. And so the quick answer to that is that they are eligible for ESG prevention services if they are not covered by a moratoria, right? So for example, someone that is not on a lease and therefore not covered by a moratoria, or someone who is being evicted because of a serious nuisance and not covered by a moratoria. And I just posted in the chat box some information about that, including a link to a resource that HUD has provided about the relevance of ESG prevention during moratoria. The other question, and you may have covered this already, but I just wanted to make sure everybody heard it, is whether or not the federal moratorium prevents landlords from taking any of the actions that were outlined in your eviction process, so notice to quit, execution order. Are all of those things covered, or is it just the final execution that's covered by that CDC moratorium?
So the legal, it's kind of a legal question at this point. It's a little bit up in the air how the courts are interpreting it. What we do know is that the executive order that extended the eviction that extended the state moratorium actually did have a provision speaking about landlords' obligations to abide by the federal CDC moratorium. And so the governor's EO was actually very clear. It says that once a landlord receives a CDC declaration, they must cease all actions to evict the tenant. So our understanding is that it would stop the landlord from taking any actions to pursue eviction. So that includes starting the case, and that includes pursuing and moving the case forward. But to be honest, these are all very new legal protections, and so we're learning more as we go through and as more court cases are heard. But it's our understanding that it should stop landlords. Landlords should respect the declaration and not start a case or pursue the moving forward of a case if they have one open. And in terms of cases that are in court, what we are seeing is that at least at the stage where courts typically would sign an execution giving the permission for the marshal to evict, that the courts are holding hearings in those cases to determine if there is a CDC declaration in the case, and if there is a declaration, and if the court determines that that tenant does qualify for the CDC declaration, that those cases are being stayed. So that is one part that does have clarity, is that in cases that are on that final stage, if the court determines that there is some sort of non-payment question in that case, they're having these hearings, and in those cases where they find that the tenant does qualify, they're staying those executions through December 31st. But in general, in terms of how to explain this to tenants, especially since some things are not as clear as others, our recommendation is if you think that you might qualify and you have an open case, to go ahead and read the declaration, go through it. If you think that you qualify, to sign it, give it to your landlord. If you have that open case, you might want to give a copy as well to the court so that they are on notice that you have given that declaration to your landlord. And I guess a related question actually that I wanted to make sure we covered was the question of if tenants do qualify for the protection of the state moratorium, whether or not they should sign a CDC declaration. So it's up to the tenant. It's because the state moratorium is pretty clear that it stops landlords from filing the case. It's a strong protection, and so tenants shouldn't, I don't think, worry about that protection if they do qualify. But if they feel that they also qualify for the CDC declaration, they can do it. One, I guess, strength of the CDC moratorium is that it does carry criminal penalties for people who violate it. So just like it could carry a criminal penalty for a tenant who violates the moratorium by falsely stating that they do qualify for it, landlords also who don't respect the CDC moratorium also have liability. So that's something to consider. But in general, the state moratorium, if they do qualify, there's no reason to worry, I guess, in terms of thinking that they also need to apply for the CDC moratorium. And one other thing, the only other thing that I would flag for tenants is Shazneen mentioned that the state moratorium, has an exception now for tenants who have 6 months or more of non-payment since March 1st. So that's kind of a moving target for tenants, because maybe this month they only have 5 months of arrears, but come November, they will have 6 months of arrears. So right now they might be protected by the state moratorium because they have less than 6 months of arrears since March 1st. But come November, they will no longer have that protection. So actually, those tenants that have arrears that are getting up there in 4 or 5 months, those tenants might be the tenants that should be thinking about whether or not they qualify for the CDC moratorium and preparing to get that declaration to their landlords if they think that they still will have trouble paying in the coming months.
Any other questions? Folks want to put anything? Yes, I think we've gotten all of this.
People can also unmute themselves and ask questions out loud. I know we have some folks that are have dialed in by phone. So if we've done some muting at our end to cut down on the background noise. So if we have muted you and you want to unmute, you can hit *6 and unmute and ask your question out loud. That's better for you.
And I would say while we wait for maybe people to gather their questions too, just to also a reminder that fair housing, all of the fair housing laws and protections that were in place prior to the pandemic still apply. And so if tenants are facing discrimination, sexual harassment, anything like that in terms of in navigating their ability to stay housed right now, they should definitely contact the Fair Housing Center with any questions or concerns, because the fair housing laws and protections still apply throughout the pandemic as well. So if people have questions regarding those, I'm happy to try and address those as well.
So it looks like we have a question in the chat box. If the tenant has already received and is at any stage of the eviction process, should the tenant submit a copy of CDC to the court as well? I think it means the CDC declaration to the court as well.
Yes, I believe that if they have already given the original signed copy to their landlord and they have a copy, and of course, assuming that they've reviewed all of the requirements and they meet all of the requirements, if they have a current case, then as Melissa mentioned, they can submit a copy of it to the court as well, and or let the court know in some form that they have submitted the CDC declaration to their landlord. And if they have any documentation or proof that of when they submitted it, that would be useful as well.
Mm-hmm. And on its face, the moratorium doesn't require it. The landlord, the protection should apply the instant that the tenant gives the declaration to their landlord. That's the important part, that every adult in the household gives the declaration to the landlord. But yeah, as Shazneen said, it doesn't hurt to notify, make sure that the court is aware that this has occurred, to make sure that the landlord and court are respecting that moratorium.
So while we're waiting to see if there are any other questions related specifically to the moratoria, I don't know if you guys, if there are particular fair housing concerns that are more prevalent since COVID that you guys have been seeing that you want to make sure people are aware of and know how to respond to.
Oh, I'm sorry. I think I just saw another question come in.
Yeah, I can take that the question about adults, and then Shazneen, maybe you can go over some of the fair housing concerns. So yeah, the moratorium order says, I believe it says every adult over the age of 18 in the household. So we would recommend every adult that's currently living in the unit, whether or not they are on the lease, just to be safe that each one of the adults sign and serve that declaration, but to first make sure that that everyone meets those requirements.
Yes, and I have a couple of slides with some information about fair housing protections or some issues that we've seen more recently. So I can very briefly share those with you in just like a couple of minutes. So these are the federal and state fair housing protections. So basically, a landlord or any housing provider is not allowed to discriminate against a tenant or even someone looking to buy a house or someone seeking shelter in a homeless shelter or domestic violence shelter based on any of these categories. So these are the federal and state categories. And in terms of, let me jump to some of the issues that we have seen during the pandemic, or questions we've received from tenants during the pandemic, some have to do with landlords or housing providers perhaps questioning sources of income. Connecticut as a state has a source of income protection, meaning that if a tenant is using some sort of rental or housing assistance, public assistance, such as a Section 8 voucher, RAP, or security deposit guarantee program, for instance, that these qualify as lawful sources of income, and landlords cannot discriminate against tenants using such income by saying that they will not accept these forms of payment. Also, for anyone living in public or low-income housing that is subsidized, they can, if their income has fallen, they can request a rent recalculation to recalculate the portion of rent that they owe. And there is actually a link on the Connecticut Fair Housing website where you can request this rent recalculation and it will automatically go to your housing provider. We've also unfortunately seen to a certain extent the rise of threats and intimidation or coercion, especially around late rent payments from landlords threatening in different ways, including threats of eviction without going through the formal court process. And just want to reiterate that this is illegal, and if this is happening to tenants, they should get in touch with statewide legal services, or if they have questions, they can certainly contact us at the Connecticut Fair Housing Center as well. And then sort of similar to that, we've seen some rise in discrimination and harassment of different kinds against some of the protected classes, specifically against people with disabilities or discrimination based on race, national origin, or ancestry, and also currently, and especially over the summer, sort of increased discrimination or harassment against families with young children at home, especially when school was suddenly canceled. And then here also I have just some contact information. Again, sexual harassment also is illegal in housing, defined very broadly as unwelcome sexual conduct or demands that make it difficult for someone to keep living in their home or feel safe in their home. If a landlord is using this type of harassment, for instance, to say that someone will not be evicted if they comply with unwelcome sexual conduct or demands, then this is illegal. And if you call us, we will keep your call confidential. We will talk with you about what options you have in addressing this issue. But please, you feel free to call us if you have questions or concerns. And also for those people facing domestic violence or know someone who is dealing with domestic violence, and the CT Safe Connect is also a great resource to get help in dealing with domestic violence issues as well. That's just a very broad overview in case, just to reiterate that the fair housing protections are in place during the moratorium, during the pandemic as well.
Absolutely. I'm not seeing more questions, and I don't give people a final last call on questions. All right, we really can't thank you both enough. Really, such great information. People just clamoring to learn about this complex topic. And like I said, folks really want to know how they can keep the folks they serve, other folks in the community, safe and in their housing and not getting evicted. And you guys were fantastic. We could keep you on all day, but I bet you have other folks to train and help out. We'd love to have you back. Now we've got you. We'd love to keep you in our web. So thank you so much. We appreciate it. Thank you to everybody for joining. And we will post the slides. The slides are in the chat box. And we will post a recording as well. So folks who haven't had a chance to watch this will send an email out so that they know they can watch the recording. And feel free to reach out to us with any questions or follow up or whatever might be helpful. But thank you so much. We're really very grateful. And lots of
Yeah,
thank you
please.
in the chat box.
Thank you for having us. And this can be, the moratoriums especially can be very difficult to sort through and understand. So please feel free to contact us if you have any follow-up questions as well.
We definitely will. Thank you, everybody. Everyone have a good afternoon. Stay safe and well.
You too. Thanks, everyone.
Thank you.